Good evening, everyone. On behalf of Justice Forward Virginia, I would like to welcome you to part 5 in our Get Informed About Police Reform series. For the next hour or so, we will be talking about mandatory minimum sentences. My name is Andy Elders. I am the Deputy Public Defender for Fairfax County, and I am a Policy Director at Justice Forward. We've got a great panel tonight, so let's take a second to meet them. First, Vernida R. Chaney is a criminal defense attorney and the president of the Northern Virginia Black Attorneys Association. Hi, Vernida, how are you?
I'm well. Thank you, Andy, for having me.
Premal Dharia is a former public defender and the founder and director of Defender Impact Initiative. Good evening, Premal.
Hi, thanks for having me.
And Dr. Ashley Nellis is a senior research assistant with the Sentencing Project. Ashley, how are you?
Good.
Wonderful. Thank you, all of you for joining us tonight. I'm going to give a quick overview of what we're going to do here tonight. We're going to cover a few topics, and I want to give everyone an idea of where we're going. The first will be what are mandatory minimums, how they came to be so prevalent in Virginia. The second will be what kind of cases are subject to mandatory minimum sentences. The third is how mandatory minimums distort the legal process. Fourth, we're going to talk about how mandatory minimums drive incarceration and delegitimize the court system. Fifth, about how mandatory minimums don't work, meaning they don't do what they aim to do. And finally, we're going to talk about how mandatory minimums impact Black people disproportionately throughout the system. So, what is a mandatory minimum sentence? I'm going to start with Premal. Can you walk us through what a mandatory minimum sentence is, please?
Sure. A mandatory minimum sentence is essentially, if you think about a floor and a ceiling, it is the floor. It's the sentence that's been laid out in the criminal code or the statute. That is the minimum that a judge must give somebody that's convicted of that certain offense. And so what that means is the judge could potentially go higher. It doesn't dictate what the actual sentence in the end will be, but it does dictate what the bottom will be. The bottom number of years or months or whatever the sentence is will be. And so what that means is it takes away the sort of individualized determination of person by person and creates a generic number that matches a particular offense in the statute as opposed to a sentence for a particular person.
And in contrast with other sentences, the judge is not allowed to suspend or reduce that sentence in any way from mandatory minimums.
Right, from a mandatory minimum, that's correct. The bottom is what it is. There's no judicial discretion or ability to go under that, regardless of what the person's circumstances are, or the context of the conduct.
For a little bit more context, I think a lot of people, especially people who practice or are familiar with the law in other states, think, well, parole is going to take care of it. They're only going to serve a small portion of what they're sentenced to anyway. Vernida, you want to explain to our listeners, our viewers, what your odds are of getting parole in Virginia?
Absolutely. And currently, the way the law is, it's almost zero. Prior to 1995, we did have what we traditionally call parole, as most people would know it. You would get a sentence and you would serve a portion of that sentence with an opportunity of being able to be released if you demonstrated good behavior and can demonstrate rehabilitation. It really acts as an incentive to give people an opportunity to have a second chance. However, in 1995, they abolished parole in Virginia. And so there is really no mechanism to get out of prison or jail once you've been sentenced by a judge or a jury. There are some few exceptions, like geriatric parole, if you're over the age of 61, or if you've been sentenced from the Youthful Offender Act, or if you've been sentenced prior to 1995. But those exceptions are so rare and they're rarely ever granted. And so if you are convicted and you have a sentence, you're going to serve majority, if not all of that sentence, pretty much most of that sentence. You get some time for good time credit. But other than that, there is no mechanism to get out. And even people who are in Virginia and people who sit on Virginia juries are astonished to learn that there is no parole or mechanism for early release for anyone who's been sentenced in Virginia.
Okay. Dr. Nellis, I'd like to ask you a little bit about the history of these mandatory minimums, sort of where they came from, why they were adopted. Can you walk us through a little bit of that background?
Sure. So mandatory minimums first sort of became popularized in the late 1980s with the first federal drug law that established mandatory minimums for drugs, and then there was 1984, 1986, and 1994, all were these large federal pieces of legislation that strengthened the carceral system and really focused in on imprisonment as the main criminal justice tool and the main crime safety tool. And the way that they did that was by extending time in prison. So they created things like truth in sentencing, which is part of mandatory minimums. And that requires that you serve, in Virginia, for instance, 85% of your sentence. So today, 90% of the people in prison in Virginia are under truth in sentencing. They are going to serve 85% of their time. And so what that, what the reason for doing it was that they thought that if, we could make these sentences longer, it would be a deterrent. And particularly with rising violent crime and serious crime, the idea was if we make these sentences longer, then they'll make the rational choice not to commit it. But the reality is far more complicated when you're dealing with people who are considering criminal conduct. First, the line of thinking assumes that people are aware of the sentencing structure before they commit their crime. And then most people who commit crime, they feel that they're not going to get caught, or they wouldn't go for it in the first place. So you're, dealing with these two realities. And on top of this, a majority of people who commit crime are under the influence. So the expectation that they're going to make this rational pros and cons argument is really unrealistic. So they, for instance, in Virginia, you can get, for selling an ounce of marijuana to a 16-year-old, you could get a minimum of 5 years in prison. I can tell you that most people who are even considering selling marijuana to a 16-year-old don't know the mandatory minimum on that term. And they wouldn't know that if they do it on school property, it's even higher. So the reality is that people just don't know. And also that what we know from crime research is that, the certainty of being caught is much more important than the severity. So if we were to redirect our resources so that there was better policing, better prevention, better intervention, not just more, but better, then we would have a much smoother system that doesn't deal with it at the back end with mandatories.
Right. Vernida, a lot of these mandatory minimum laws were passed in a very specific era, and they seem to suddenly appear at the state level in all these different states in a very short period of time. Do we have an explanation for where the sudden push to adopt all these mandatory minimums was coming from during that time period? Absolutely.
There was a concerted lobbying effort in the 80s and the 90s to push for, as we previously talked about, truth in sentencing. It was pushed and billed as something that was going to be helpful for people so they can understand what they're going to be sentenced to. But really the effect was to increase longer periods of incarceration for people. And it had a disproportionate effect on minority communities, brown and Black people. And there is a financial incentive in keeping people incarcerated. There are essentially two big operators of for-profit prisons. And that is CoreCivics, what used to be operated as Corrections Corporation of America, which runs a lot of the federal prisons, and then GEO Group, which also runs federal prisons, but also runs one of Virginia's largest prisons, which is Lawrenceville Correctional Center. It's been, I think, operating that facility since, I believe, 2003. And before that, I believe Corrections Corporation Center was doing it. These are multi-billion-dollar corporations, and they have millions of dollars in profits. And they also have a long reach in the number of people that they hire as lobbyists and the amount of money that they spend for lobbying that. So they are contacting politicians and lawmakers to push the agenda to keep people incarcerated. And they're building relationships with police groups, associations, to kind of beat the drumbeat that in order to have safety, we have to have more prisons and we have to have people incarcerated. And ultimately, it just increases their bottom line.
People who pay to do the incarcerating are the ones telling us that more people need to be incarcerated for longer periods of time.
Right. I think we have a slide that actually shows GEO group.
I'm going to try to pull it up. This is my first attempt to share my screen, so we'll see how it goes. Okay, it looks like it's up to me.
Right, and you can see from this slide over the years that the GEO group has been using their financial power to increase their lobbying effort. They have about 16 lobbyists now that they work with, and you can see back in 2019, they spent $1.4 million just in lobbying efforts. And this lobbying effort isn't about healthcare. It's not about, childcare. It is simply about keeping people incarcerated to increase their bottom line. The other thing that we should really pay attention to is even for facilities that are not for profit, right? They're run by our local jails. They're run by the state Department of Corrections. In Virginia, it would be the Department of Corrections. There's still a financial incentive to have people incarcerated. I mean, we know that the 13th Amendment abolished slavery and also involuntary servitude. However, we have men and women that are behind prison in jail that are simply working for little to nothing or for free. Virginia has a Virginia Correctional Enterprise, which is called the VCE, and it is a revenue producing program that requires people or have people that are incarcerated to produce products, supposedly for the benefit of taxpayers. State agencies, colleges, universities, even our lawmakers in the General Assembly have to buy certain products like furniture and pens and papers and things like that from the VCE. And that revenue isn't given back to the inmates. It is essentially used to help run these facilities. And so I think what we're able to see is that there is an exploitation of having people incarcerated, and having more people incarcerated for a longer period of time has a financial incentive to either profit-making industries or even our state and local jails.
So I want to turn to what kind of offenses are subject to mandatory minimums in Virginia. The list is long. There's over 200 offenses that are subject to mandatory minimum penalties, and it's a broad array of offenses, but I'm going to run through real quickly just to get a broad view of it, and then we're going to go back and talk about some of them specifically. There's a class of sort of victim-specific mandatory minimum offenses. Assault, as a general case, is a misdemeanor, doesn't carry any mandatory time. But if the victim of the assault or the person who's testifying and saying that it happened is a police officer, then it's a felony with a mandatory minimum sentence currently. We're going to talk about that a little more because there are legislative efforts going on during the special session to change that. But also, the same thing applies if there's an assault on school employees, on healthcare workers, firefighters. There's a number of other subcategories of people. And especially once the assault on a police officer became a law, all these other people said, we went in on it. There's other classes. There's drug distribution offenses. There's firearm offenses. There's a number of traffic offenses, including both DUIs, which is somewhat less shocking, but also driver's license offenses. Driving after your license has been suspended can carry mandatory minimum time. There are more serious cases like child sex offenses. And then there are really absurd mandatory minimums like possessing too many untaxed cigarettes can get you put in jail on a mandatory minimum sentence, or illegally selling alcohol can get you put in jail for a mandatory minimum sentence. As Dr. Nellis said, I can't imagine that any of the people who are engaging in those kind of activities have any kind of thought that they're going to be facing a mandatory minimum sentence. But let's go back through and talk about some of those, take a second to focus on a few of those offenses. Vernida, talk to us about the assault on law enforcement statute. We talked about it a little bit last week, of course, but I'd like to talk a little more about sort of the legal side of it as opposed to the factual side.
Right. Assault on a law enforcement, I mean, most people are familiar with simple assault, but there is a provision in the assault statute that says that if you assault a law enforcement officer, that you can be charged with a felony, and if you're convicted, you can have a mandatory minimum of 6 months in prison. If the person wasn't a law enforcement officer and was just a regular person, it would be a class 1 misdemeanor where the maximum penalty would be 12 months in jail, and there would be no mandatory minimum sentence. As we talked about earlier, there was a push in the 80s and the 90s to have these mandatory minimum sentences, and we had an assault statute on the books in Virginia before there was assault on a law enforcement officer. But in 1997, our General Assembly amended that law to include the mandatory minimum sentence in the felony part of it when it relates to law enforcement officers. And what we saw over the years, 1999, I think 2000, 2003, quickly they added to that statute to have that statute include other people as well, as indicated, like people who work for the schools, firefighters, that type of thing. And these all have mandatory minimum sentences. If they didn't have the job they had or the role that they had as far as their profession, it would really be a simple assault, what would be a misdemeanor. And what we found, and we're going to talk about this more, is that the mandatory minimum sentences reinforce racial biases that people have. And it also reduces the ability to challenge the police conduct. And we'll talk about that a little bit more with challenging the police conduct. But we often find in these type of cases, especially assault on police officer cases, that oftentimes the police has some misconduct in how they behave when they engage with citizens, oftentimes rising to the level of excessive force.
Right. I remember specifically that when Breonna Taylor was killed, initially they charged her boyfriend, who was inside, with assault and firing on the police who had broken into their home and began firing. And initially they charged him until there was such an outrage about what had happened that they dropped those charges. That is a much more serious version of it. But I think as practitioners, we see a lot when an officer roughs somebody up, that suddenly there's an assault on a police officer charge brought against the person who was the victim of that police violence. And I think that causes a lot of people concern.
It does.
Yeah, there's going to be a lot of these things that we're talking about here aren't going to be subject of legislation, very likely in the special session, or at least currently, to our knowledge, aren't. But the assault on a police officer is getting a lot of attention, and there's definitely going to be a push to eliminate that mandatory minimum sentence from the assault on a police officer statute. So that's something we're certainly eager to see happen. Let's talk a little bit now about drug distribution offenses. It's not that every drug distribution offense carries a mandatory minimum in Virginia, but certain classes do, selling on school grounds, selling a certain weight. Dr. Nellis referred to selling more than an ounce of marijuana to someone who's 16 or younger. Premal, when the federal system has had a lot of experience with mandatory minimums in drug offenses, how does that work? Does it reduce people distributing drugs? Does it help fight the war on drugs, or does it just put a bunch of people in jail?
Yeah, I think as Dr. Nellis was saying earlier, a lot of the creation of these mandatory minimums, particularly those that relate to drug offenses, stem from the original war on drugs that our country undertook, which we now fairly universally realize to have been misguided. And yet we still have mandatory minimums attached to many drug offenses in Virginia and federally and in other states as well. And sort of one thing to note about a lot of those offenses and the way that the mandatory minimums attach is that they're connected to the amount of drugs, to the weight, which of course is disconnected or divorced from conduct or alleged conduct in the case, right, for the most part. And so that just sort of further highlights how disconnected mandatory minimum sentences are from individualized determinations when we're talking about sentencing and how judges fashion sentences.
And we'll talk about this a little more later, but a lot of times, since the police are the ones setting up the drug deals, they're the ones setting up how much weight is brought to the deal. And they do that so that they can get the mandatory minimum sentence.
Yeah, and drug offenses are also really important to think about in the context of policing and in racially disparate results, because so many neighborhoods, are over-policed, because neighborhoods where Black residents live are over-policed, and drug offenses come in large part from over-policing and from those sorts of street encounters and police targets. So that's an important connection to draw.
As you might expect, some of the offenses that mandatory minimums attach to are among the more serious offenses that we encounter in the criminal legal system. Child sex offenses have a lot of mandatory minimums attached to them. I think it's important to understand that mandatory minimums as a policy, maybe they're not, maybe it's not even right to think of them as a policy, to the extent that mandatory minimums are bad policy or a bad technique, they're bad in every case. And if it's wrong to divorce discretion from sentencing, for example, it's bad in every case. I hear a lot of people say, well, if it's a nonviolent crime, there shouldn't be a mandatory minimums attached with it. But it always seems to me that if mandatory minimums are bad, they're bad no matter what, and not just bad in cases where we disfavor the conduct more. There's one thing that's particularly troubling to me as a practitioner who handles serious cases, is that child sex offenses, some of them carry mandatory minimum life sentences. And the idea that someone who commits an offense, no matter what their background, no matter what happened, has to have a life sentence no matter what, is extraordinarily troubling. And I know, Dr. Nellis, you've done some research on the effect of life sentences and on the policies associated with them. Can you tell us a little bit about what's wrong with a life sentence, why life sentences aren't good policy?
Sure. So first off, there's been a very dramatic increase in the number of life sentences nationally and in Virginia. Now that, to the effect that now 1 in 7 people who is in prison is serving a life sentence. So we have a very massive over-incarceration issue, considering the fact that crime has been going down for, over 2 decades now. So in Virginia, there are over 500 people serving life imprisonment out of the roughly 2,000 who are there for a sex offense. And the range of crimes that can result in a life sentence through a mandatory is pretty broad. So you may have an instance of, varying ages, over 18 and an under 13 interaction that could be considered to be statutory rape, all the way to child pornography and a serial rapist. So there's a broad range. And of course, the internet has created lots of opportunities for people to engage in criminal conduct. And so what we're seeing, as I've studied life sentences, substantially over the last decade, is that the fastest growing crime of people serving life is these sex offenses, because legislators just keep piling on more and more offenses, right, as mandatory minimum of life, because it's hard. There's a misunderstanding that people who are convicted of a sex offense are you can't change them. That's something you often hear. You just can't change somebody who's convicted of a sex offense. When in fact, the research shows that you actually can, that they're some of the most rehabilitatable offenders out there. They're the most amenable to treatment if they're given the right treatment. So there's really a mismatch, in terms of, so when we create these mandatories, we're doing it because we think this crime is so bad, we have to pile on a bunch of years, instead of this person has this chance for success, and it will take us this number of years to get them back on track, which is what other countries do.
You see cases where 19-year-olds or 18-year-olds have girlfriends, for want of a better word, who are 13, and it's like an ongoing relationship at times where the parents even know about it. It's not what you would want as a policy, but the thought that someone like that needs a mandatory life sentence is extremely troubling. We also see cases where people were themselves previous victims of sexual abuse as children, and then they go on to abuse when they're older, but suddenly the system doesn't care about their prior abuse. They don't care about whatever they may have been going through themselves. That the system purposefully tries to divorce that judgment and mercy, which is obviously a very frustrating thing as a practitioner who's trying to protect someone who has a trauma background and things like that. I've been asked to remind everyone in the audience.
I offer one example of Cyntoia Brown, who is a Tennessee, she was a Tennessee prisoner. But this is a growing issue of sex trafficking of children, and having then the children, prostitutes in her case, sex trafficked victim, is a more appropriate term, retaliate and kill one of their customers, which is what she did. And she ended up with a 60-year life sentence, which was only commuted because a celebrity caught wind of it. And there are hundreds of people like that who are in a situation like hers.
And we see cases where the child solicitations come with 5-year mandatory minimums if the ages are 7 years apart and the child is under 15. We see situations where a 23-year-old is, or 21-year-old, I suppose, is in a chat room and someone comes across them who is obviously a detective pretending to be a 14-year-old, and they have a conversation about sex, and suddenly that person's looking at 5 years mandatory minimum. In contrast, if a 21-year-old actually has sex with a 14-year-old under Virginia law, it's a 10-year maximum offense with no minimum at all. And so sometimes these things get so far out of whack, and sometimes it's in response to whatever becomes the big scare of the day. We saw To Catch a Predator, and we saw things like that, and suddenly people are terrified that this thing's going to happen. And for 20 years, whatever the problem was, the answer was mandatory minimums. If there were DUIs or people were afraid of DUIs, then the answer was a mandatory minimum. If people were worried about selling drugs at school, the answer was a mandatory minimum. But over time, we've built up this bizarre system where people are not being punished fairly, and there's no rhyme or reason to what's going on. Okay.
Another important point to
Yes, please.
To focus on that as well too, and Premal brought this up. Oftentimes we find in cases with mandatory minimums, we find that law enforcement is actively engaging in trying to create criminal activity to meet the mandatory minimum. And Andy, you just referred to it as well when you talk about sex cases and law enforcement officers going into a chat room and deciding what age they're going to say that they're fictitiously using, right? They don't go to the higher age. They go to the age that's going to trigger a mandatory minimum. And the same thing.
They're pretending so they can make up any age they want. They could say 15 or 14, but they always say 14.
And the same thing happens in drug cases where law enforcement perhaps have come across some criminal activity, maybe legitimately, but they will continue to engage with our clients to have them continue to sell drugs so they can meet this mandatory minimum. And, some people, lay people will think that this is entrapment. The police can't do that. They can't do that. And it's not entrapment. They are allowed to do that. And that's part of some of the ways that they can, quote unquote, investigate cases. But we often find in a lot of our cases, it has more of an effect on Black and brown people, and they will allow the criminal activity to take place so they can meet these mandatory minimum sentences.
This is a good segue for talking about how the presence of mandatory minimums changed the trajectory of the entire case, of any case that they apply to in the criminal justice system, even before sentencing even happens, and how much it can distort how the criminal justice system works. And I want to walk through each step and talk about what mandatory minimums can do and how they can change the way the system's supposed to work. And Vernida, you just referred to it, talking about investigation. Obviously, I think people understand this, that ultimately officers and detectives are the ones who decide what to charge. They'll investigate, as they investigate, they look for certain facts to figure out whether they can charge X or Y. When they go to arrest someone, they go to the magistrate and they present the facts to the magistrate, and the magistrate makes the decisions based on the facts that the detectives or the officers give them. So that means that at an early stage, the police who are aware of these laws and are thinking about them are deciding, for example, as Fairfax did during the second week of COVID, whether they're going to create an entire enforcement action surrounding a mandatory minimum offense, which they did with child solicitation, or whether an officer who is working on the drug task force is going to try to set up certain kinds of drug deals. And what this results is what I think of as kind of teaching to the test, right? Where the punishment drives the creation of the crime by the police. And the prime example I can think of, Vernida, is a thing that you were talking about a little bit. One of the mandatory minimums in Virginia attaches to selling drugs in or around a school. And there's a school zone and it's defined in certain ways. But I've seen more cases than I can remember for myself and my colleagues where a police officer starts to get someone, they get somebody on the hook for selling drugs. Probably they found a user, they found drugs in someone's car maybe. They got that person to coordinate someone selling drugs to them, and then they get what they think is a drug dealer. And then once they're talking to that guy, they'll say, okay, I'd like to buy from you again. Can you meet me? And they give them an address. and that address happens to be in the parking lot of a school or adjacent to the parking lot of a school, but within a certain number of yards of it. The person selling the drugs is not selling it to people who go to school. They're not selling it to students. They didn't choose the location. The undercover cop chose the location, but they choose it specifically so that a greater penalty will apply and a mandatory minimum penalty will apply. And you see this in so many different instances where mandatory minimums are available, that the officers specifically create the crime to hook people into the mandatory minimum sentence.
And if I can just add this, you're absolutely right. And you mentioned the word task force. And this is, again, it's one of those things where you have to kind of follow the money.
Right.
For those of us that do state court cases and federal cases as well, too, we see a lot of overlap with cases that start in the state court or involved in local police investigating them, and then they're turned over to the federal authorities to be prosecuted in federal court. And what we've been able to learn is that law enforcement, particularly on a local level and sometimes on the federal level as well too, they're not necessarily targeting the crime based on need. They are targeting crimes based on financial resources. And oftentimes, as far as the local police, local sheriff's office, a lot of times they receive grants and funding for certain task force. And it's not because there is a need necessarily to kind of investigate these type of crimes, like you're talking about online solicitation. I don't know if there was a urgent need right at the beginning of COVID to go out and put this task force together.
A crime that they could enforce without leaving the house. They were trying to find
Exactly.
social distancing crimes, and so that's how they did it.
I mean, everyone was on quarantine lockdown. No one was meeting anyone, presumably, right? But
None of them did meet anyone. It was just all talking on the internet.
they thought that it made sense to go ahead and go after this crime at this point. And, you know, law enforcement, we hear a lot from law enforcement that they do more than just arrest people. And we know that they're here for safety as well, too. But at the time when we all kind of needed safety, right, in our community, they were using their time to go online to pretend to be 14-year-old girls.
And we'll specifically talk about those cases. They were going into adult rooms where you had to be 18 to be in the room, talking to people who were there to talk to other 18-year-olds. They'd talk to them for a while, and then they'd start pretending that they were 14. And the person, a lot of times, they just didn't believe them, but they still got charged, and a lot of them are still being held in the Fairfax County Jail right now.
Right. And
Okay.
for the financial interest. Yeah, absolutely.
Right. So let's move a little bit to plea negotiations, which is another place where the existence of mandatory minimums can just really radically distort how the system's supposed to work. I think a lot of people don't know, jury trials in Virginia are now down to 1.3% of all verdicts, all convictions come from jury verdicts. So that means that it is the vast minority of these cases are decided by juries. And part of the reason is because the leverage that prosecutors have in these things. I want to talk about the leverage a little more length in a minute, but first, Premal, I'd like to talk a little bit about when you give a prosecutor the power to say, I know that there's a mandatory minimum of 5 years if they're convicted, what impact does that have on how the prosecutor functions?
Yeah, so this is a really important point because I think also for people who don't, go to criminal courts every day and either experience them or practice in them, there's this vision that the judge is sort of in charge or sort of, responsible for a lot of these decisions, and actually a ton of power rests with the prosecutor. And what mandatory minimums in particular do is they literally just take power away from the judge and give it to the prosecutor to make decisions about how the case is going to go and what the result is going to be in many ways. And so prosecutors can, they have discretion to make charging decisions based on that power. And that's, problematic in this context for a number of reasons. First and foremost, building off of the bias and structural discrimination built into the policing that's led to the situation in which people are in court, prosecutors themselves, of course, are, replicate their own bias, and that's baked into their charging decisions. And so, studies have shown that prosecutors often make charging decisions based on perceived ideas about the likelihood of recidivism, or the threat to public safety, or things like that that are not based in any kind of reality or data, but that are sort of based on their own inherent bias. Studies have also shown, sorry?
Anecdotes and hunches.
Exactly. Studies have also shown that that it matters that prosecutors are overwhelmingly white, right? I think 95% of elected prosecutors in the United States are white. And that's a staggering number when you consider the people that are being charged in the criminal system in the United States, who are disproportionately Black and brown. And so all of those things lead to bias and to discrimination and to racially disproportionate results in charging decisions. And so that's an important piece when we're talking about the power that prosecutors have about what happens. And when they charge offenses that have mandatory minimums attached to them, they're setting up a series of events that's grounded in what that mandatory minimum triggers, right? It triggers power and control over the person that's charged and what kinds of decisions they're going to make, because it changes the risks, it changes the potential outcomes in a way that really takes power away from all the other players and really firmly puts it in the hands of the prosecutor. So that's important for plea bargaining, as you described, but it's also important for a number of other pieces of the process. I think we envision that our criminal system has all of these constitutional rights baked into it and there's due process, but really when you start to charge people with offenses that carry mandatory minimums, you've taken away a lot of that because of the leverage that gets exerted. And so people's ability to make choices that are truly independent and grounded in their own individualized decision making is taken away. But also some of the things that we rely on in the adversarial system. And in particular, I'm thinking of police misconduct and police violence, which of course is increasingly part of the national conversation around the criminal system, as it should be. But in our court system, accountability for police comes through the ability to challenge their conduct by defense lawyers in motions hearings and in pretrial hearings, and in the context of cases where you get discovery and you get the evidence and you're able to see it and cross-examine witnesses and make those kinds of challenges. And often in mandatory minimum cases, prosecutors are able to take that away from people as part of the bargaining process. And when you do that, not only do those individuals lose an important right and control over their own fate, but communities lose because police misconduct goes unaccounted for and unaired. We don't find out about it. And that's just a really important thing for people to understand.
Right. Another big part of this process is, we talked a little bit about the power that you give to a prosecutor. I know Vernida and I assume Premal, when you were practicing as well, have seen firsthand the effect that it can have on an accused when the prosecutor, or in some cases their defense attorney, explains that there's a 5 or a 10-year mandatory minimum. And we talked about this a lot lately, is that imagine if you're someone who's charged with an offense like that and you think you didn't do it, you want to have your day in court, the power that would have over you to know that if you're convicted, you're going to get 5 straight years and no one can do anything about it. You can't make your case to anyone. And the prosecutor knows that, and the prosecutor says, okay, you can do 2. Or you can plead guilty and be a convicted felon for the rest of your life at 19. And the system is supposed to work so that if you're accused of a crime, you can confront the evidence against you, you can testify and tell your story, you can have your lawyer attack the evidence, attack the witnesses and say, this isn't what it looks like, I didn't do this. But you don't have that power when there's a mandatory minimum life offense. And people talk about child sex and they say, well, it's not a big deal, those are terrible offenses. And I say, if you were charged with one of those offenses and didn't do it, whether or not you got your day in court would be everything in the world to you. It would be the end of your life. And people don't put themselves in that position. They put themselves, they assume that the person's guilty, which obviously is not what our system's supposed to do. Vernida, you had a case, not quite that high a stakes, but under the assault on a police officer statute that's gotten a lot of attention lately. And I wanted to ask you to talk about a little bit about what happened in that case and how it impacted your client to know that there was a mandatory minimum facing him.
Absolutely. This was a young minority woman that had recently just had some services at a hospital. She was having some challenges. Went into a Dunkin' Donuts to try to see if she can get help from the police to get a ride home. She actually still had on her medical bracelet. There was some issues about whether or not they could help her, if they could get her a ride home. And at some point she became agitated and threw a food container down on the ground that contained some cooked onions, some onion rings, some little pieces of onion. And at one point, out of frustration, she took, as the officer testified, a small sliver of onion and threw it at the officer's shoulder, and it hit him where his badge was on his shoulder. It was at that point they got very upset with her. They slammed her against the glass window. She injured her mouth, had blood coming out of her mouth. They claimed that as she was trying to essentially breathe and get the blood out of her mouth, that she spat on one of the officers, which landed on his shoulder. And she was charged with 2 felony counts of assault on a police officer and another misdemeanor count. In this particular case, in most cases, Andy, you're absolutely right. It takes away a lot of the rights from our clients. And oftentimes when we go to court, as either part of trying to cover up the officer's misconduct, the prosecutor may offer our clients some type of way of resolving the case short of the mandatory minimum, but definitely with some punishment. In this particular case, we had a really strong belief of 2 things. One, my client didn't do anything wrong. And 2, that the officer wasn't injured and it didn't fall under the assault on a police officer statute. So we were able to litigate this case through the preliminary hearing stage, through the suppression hearing stage, and all the way up until the day of trial. And it was the day of trial that my client was faced with a choice, a really hard choice. Whether do we go forward with a trial and try to vindicate ourselves? But we take the risk. If we are found guilty, the jury has no choice but to give you a mandatory minimum. The judge has no choice but to impose the mandatory minimum. There is no mechanism to do anything else. Or do we take a guarantee of a misdemeanor? And after a lot of consultation, she decided to take a plea to a misdemeanor.
And I think this is a thing that people don't understand. I hear a lot of people, legislators and other people in the system say, but the prosecutor wouldn't let someone serve 6 months on a case like that. They'll make them a misdemeanor offer or they'll work something out. And I tell them, it is the fact that they make the misdemeanor offer while having the threat of the felony that is so coercive. The fact that the misdemeanor offer is made is good in a sense because it gives them an out, but it gives them an out that is a conviction that they don't deserve.
Absolutely.
And denies them their day in court. The fact that the prosecutor has that discretion is what makes it coercive.
Absolutely. Absolutely. And in this particular case, well, in all cases, I mean, in Virginia, and I think this is something that everyone should recognize and know, if you're convicted in Virginia, you are forever convicted in Virginia. There is no expungement or a way to get that conviction removed from your record. It doesn't matter if it's a misdemeanor or a felony. It doesn't matter if it was 20 years ago, or it doesn't matter if you didn't even get a jail sentence. You got some type of fine or some other type of punishment. It is going to remain on your record forever. And oftentimes with misdemeanor cases and felony cases, especially in Virginia and especially in Northern Virginia, there's also this added sentence or added punishment of probation that you have to do. And this particular client had to endure 2 years of probation on top of that as well. And so I have no doubt in my mind, particularly for this particular case and some other cases that I've had, that the reason why my client was charged with assault on a police officer with a mandatory minimum of 6 months and a felony offense is because of the misconduct of the officers. The officers in this case exercised undue force on her, injured her, and tried to cover it up by charging her with 2 felonies.
So Dr. Nellis, we've been talking about the threat or the specter of these mandatory minimums, but they are often applied. They actually do result in mandatory minimum sentences. Can you tell us a little bit about what effects mandatory minimum sentences have when they are applied either by judges or juries?
Sure. Mandatory minimums, and my specialty is studying life imprisonment as a mandatory. They have contributed significantly to the bloating of our prison population. They are the main driver of the prison system that we have today, which is, we are, 4% of the country and 24% of the incarcerated population in the world. And so we are an international outlier in that regard.
You're talking about U.S. population in jail in the world. Mm-hmm.
Right. Yeah, I think I said country, I meant world.
Mm-hmm.
So the impact they have globally and, on our prison system, on our criminal justice system is really, has been really handicapping and destabilizing for our entire system and the trust in the system. But also if you look at the individual, we were just talking about how you're on probation and you always have your conviction. So when you have a conviction and a prison term, even without, and you come out and you have a felony conviction on your record, what that means is that you are, everyone who you apply for a job with, every place where you try to live, when you try to vote, if you try to get on public benefits for having financial hardships, like a lot of people in the US are having right now, if you have a felony conviction, that can severely hamper your outcomes there. So when we incarcerate people on these low-level mandatories, let's say, where it's a 6-month or even a 30-day mandatory, but we put them in the prison system and we expose them to the prison system, statistically, it's more likely that they're going to come out of that prison system and commit more crime than if you did nothing. And I know that's hard for people who work in the system to believe, but for certain offenders, if you do nothing, it is much better for public safety than if you incarcerate. Then at the high end of the system, so let's say you give somebody a life sentence, right, at the age of 26, that's about the average of somebody coming in on a life with a murder conviction. All offenders, and in fact, all of us who aren't offenders, we age out of our behavior. So the behavior that we engage in, and while the vast majority of us don't engage in murder in our 20s, but all of the behavior we engage in our 20s, we look back at in our 40s, and we are amazed. And that is because of the brain development. And that is because we don't, in our 20s, usually have these attachments that we get as we mature, right? We get a job, we get married, we have kids, we get these connections to the world, and that sort of solidifies our path. When you interrupt that and you put somebody in prison and then they age out, and they do age out, you see that also in the incarcerated population because you see their disciplinary records die down. You see them taking on mentorship roles, getting a solid job, having, very lifers in particular become model inmates. Mm-hmm. What you're doing is you're incarcerating somebody who would serve the community so much better if they were on the outside. And they are a very low risk for recidivism. We see this for lifers that do get released. That doesn't happen very often in Virginia, but it happens in some places. And we, study their behavior. They have a recidivism rate usually of in the range of 1% to 4%. So people who are incarcerated for decades and decades, we're incarcerating them way past that point of their dangerousness. And so all of that care that we provide to them at the taxpayer's expense really could be used for them to contribute to society. I'm
going to put up a slide here that shows Virginia incarceration rates, and you can see the jump here in the 80s and into the 90s from the war on drugs, and then you can see this second jump here. And this is exactly the time period in which these mandatory minimum sentences started getting passed into law and then started taking effect. And you can see that jump. And it's to be able to see it that clearly is really extraordinary.
And, I'll say also while you have this slide up that, a lot of states have begun to rethink and to scale back their mandatories. We're seeing prison populations decline by 40% in states like New York. that are really seeing some massive improvements in their system to make it more, is it more flexible? I mean, New York has ways to go in other ways. So I don't mean to let it off the hook, but it has, without hurting its crime rate, it has depopulated significantly, and so have several other states. Virginia is one of the few states that has continued to rise in its incarceration despite not having a very serious crime problem, and that's because of these mandatories. Because judges' hands are tied. That once a case gets beyond a certain point, then the judge's hands are tied, and that person is going away for a long time. And that's why these incarceration rates just don't budge.
And it's a matter of policy, but there's also just a moral component to saying to a judge or a jury that you're going to put this person in prison and you're not allowed to exercise mercy. Right. It's literally, like I've said before, literally a prohibition on mercy. And if someone came to you and I said, I've got a great idea for the criminal justice system, let's make it so you're never allowed to cut anyone a break for any reason, you tell them that was crazy. But at some point in our sociology, or in some point in our culture, we became so afraid of people committing crimes that I feel like we just turned part of our brain off. And it's always so extraordinary to me to hear people say, well, we can't take these things away. The crime will run rampant in the streets. And it's not as though judges or juries still can't decide what the punishment should be. Mandatory minimums aren't the law itself. You can take the mandatory minimum away and still have people punished in whatever way a judge or a jury sees fit. And we choose them so carefully. We spend so much time picking out judges and juries that to say they're not allowed to exercise their judgment is just shocking to me. It just leaves me shaking my head.
I mean, I think some of that is unfortunately explained by who is going to prison. So, we have arrest rates for African Americans that are nearly 3 times the rate for whites. And we have incarceration rates for African Americans here in Virginia that are 6 times the rates of whites. And so, there's this idea that, these lives don't matter. And that, that these are of less worth. I am 100% certain that if we had the incarceration rates of white people that we have of Black people, and that it was reversed, we would be moving this, along a lot more quickly. But it's this, sense that, we've just been, beaten down with this idea that Black people are just inherently criminal, that we just accept it,
And you can see in that last screenshot that Black Virginians make up 19% of the population and 58% of our jails. And I'm going to show you another one here. I'm going to show you another one here that shows rates by ethnicity. And you don't really have to know anything about math to know that there's something wrong with this.
And it's not, even if that, one point I'd like to make here is that a lot of research shows that there is some crime that is explained by race. You can explain a lot of violent crime by race, but when you show the discretion in the whole system, when there is discretion, it's much more likely that African Americans are going to be harmed. The more that is removed, the less likely it is. And so, even if that was like the way it is, even if there was a 6 times the rate Black to white incarceration, that itself is a problem that we should be addressing, but we don't. We just say that's okay, and that seems to me like just so without mercy.
But Dr. Nellis,
I'll just say some of the proponents for mandatory minimums say, well, the reason why we want to have the mandatory minimum is because it takes the discretion out. And so we're going to treat everyone equally and the same. But we know, not only from research, but also from our work, that there is a lot of discretion that happens before that. And that's where the problem comes in. So everyone's not treated the same when they have contact with the police. They're not treated the same when they're stopped by the police. They're not treated the same when it comes to discretion as far as charges. And then they're not treated the same as to how the case is resolved. And so when you get to the sentencing portion, it is just unfair to say that at that point, everyone remains equal. So if everyone gets the mandatory minimum, then there's no discrimination. And this is the proper way to do it.
Right, right. So we've talked a lot about the costs that we're paying to have mandatory minimums in place. Do they work? Is it worth the benefit? Are we getting what we paid for? Dr. Nellis?
Right. I mean, I think, what we're basically getting is these diminishing returns over time, because you have, in Virginia in particular, which has a very strict geriatric release protocol, you have people, a growing number of people who are dying in prison. And whereas, they could be out with their families and being cared for and paid for by their families, they're being cared for and paid for by the state. So, just from a financial perspective, we're definitely not getting what we, thought we were getting. What has happened really is that shift in discretion that people who argued for mandatories at their start thought, well, we take the discretion away from their judges, but we just shifted it over to prosecutors. So we still have the discretion. It's just now it's in the hands of somebody that really shouldn't be using discretion. It should be in the judges. That was their job. So, I would say that, we really haven't, gotten any bang for our buck in terms of mandatory minimums.
You said that other states have gotten rid of their mandatory minimums and not seen increases in crime as a result.
Some states, states have, by and large, and I'm no expert on all states' mandatory minimums, but I do know that, it's difficult. Even look at the federal system. It took years to get the Fair Sentencing Act passed. And then when they did get it passed, it wasn't even 1-to-1 anymore. It was, the crack law got better, but it wasn't removed. And if it's unfair, it's unfair. They made it less unfair. And even that took like 20 years to pass that law. So it's difficult. I think one of the bottom lines here for going forward is that it's much more difficult to repeal a bad law than it is to enact a bad law. We have these trigger responses, and something terrible happens out in the street, like Len Bias, which led to the whole crack epidemic. And he wasn't even smoking crack; he was smoking powder cocaine, sniffing it. And then we have this entire, avalanche of laws. And then 20 years later, all of those thousands of lives later, it takes, decades to roll that back. And, it just goes back to my point that these are largely Black and brown lives, which, we have to make those matter more than we have from start to finish.
Premal and Vernida, can you walk us through a little more about how these seemingly equal laws disproportionately affect people of color in the system?
Sure. And I think this, echoing what Vernida and everybody on this panel has said thus far, in some way, there's a compounding series of events, right? It's not just what happens in a courtroom that leads to people's lives being harmed. It's the structural inequalities to begin with. It's housing segregation. There's so many things that play into then policing, then to charging decisions, and then to quality of lawyering. There's just so many pieces that go into that puzzle, right? And at every stage, data has shown and evidence has shown that Black and brown people are disproportionately negatively affected. And so I don't think there's any question in the charts that you showed earlier about incarceration rates, show that that's true. So there's that. I want to sort of just go back to one piece when we're sort of a stark number that kind of highlights some of the ways in which decisions and how the court process gets changed. And again, all of these things are disproportionately experienced by Black and brown people. But in federal court, for example, about 30 years ago, or around 30 years ago, which is consistent with that chart that you showed around the time that we started really, implementing these mandatory minimum rules, there are about 20% of cases were resolved through trials or went to trial in federal court. And
20% went to trial?
I'm sorry?
20% went to trial?
Around 30 years ago. And I believe this to be true. But now fewer than 3% of cases do. Right. And that's not random. That doesn't just happen. All of these things are the result of decisions and policy choices that we've made as a country and as states and jurisdictions that make laws. And so it's, it results in real harm to real people's lives. It results in the devastation of actual rights that people believe that they're entitled to and that our communities believe that people are entitled to. And those people are disproportionately of color.
Vernida?
Yeah, I mean, absolutely. I mean, it's without question. We see it in our data, but we also just see it in our everyday lives, particularly us who are Black and brown people of color. Our families are touched by this. And it is a difficult system for us to have to navigate and have to make these choices, particularly when a mandatory minimum is involved. It increases the leverage that the criminal justice system has. And for Black and brown people, oftentimes they don't consider this justice. It is an injustice to them, making sentences harsher for crimes that if they weren't going after brown and Black people, we would think that they probably wouldn't have these type of harsh penalties and sentences for them.
So I'm going to try to take about 5 minutes. I think we're probably at the 1 hour mark, more or less now, to try to take a couple of questions here. If you're on Facebook and you want to submit a question, we're going to try to answer one or two here. I do have a question from Nina Zaretsky asking how we can overcome the power of lobbyists and politicians other than by voting. And one of the things that, and so I think this harkened back to some of what Vernida was talking about and the impact that some of the lobbyists can have, especially on the state legislature. And I think the easiest answer is that you, as a person who is, if you're a Virginian, you should be contacting your legislators and letting them know what you think about these issues. Justice Forward regularly puts out policy updates. If you get on our email lists, where we tell you when votes are coming up, what legislation is being submitted, and when we have action moments. And it is really imperative that legislators hear from their constituents about issues that they care about. And I don't know how many times I've been talking to a legislator and I'm bringing up an issue and they're saying, yeah, we've been getting lots of calls and emails about it. And it really does seem to affect them. And I think it feels like it's naive or something like that to think that legislators care what individual people say, but ultimately those are the voters, and they're trying to, to the extent that those voters have something to say and that they have a strong position on an issue, they care. I think that matters. There's a question about how can legislators respond to the criticism that voting to end mandatory minimums is being soft on crime. I'm going to let the panel try to answer that. How should legislators respond to the idea that getting rid of mandatory minimums is soft on crime?
Well, I can just start by saying that when judges are, given the power to be judges, they often act within, not almost all of the time, they act within the guidelines that, are set out for a range of sanction. And so, they're still judges without mandatory minimums. There's still prison. There's still incarceration if that's necessary. It's just getting away from this idea that we just have to have this mechanical response to certain crimes that doesn't take into account the individual's, individual factors of the incident.
And I would also say this too, it's particularly to legislators. Legislators have now given the discretionary power to charge someone with a mandatory minimum to essentially the police and then by extension to the prosecutor. And legislators in Virginia elect the judges. They go through a screening panel, they do a vetting process, and they say, this is who we want to preside over our judiciary here in Virginia. So the question becomes, why would we want to relinquish this power, this great power of imposing mandatory minimums to local police officer who have very little facts about the case, certainly have no mitigation or information about the person who was involved in the crime, a prosecutor that is dealing with possibly an excess caseload who may only have some information, but not all of the information about the case. And why wouldn't we want to give that discretion and power to a judge that has been vetted and elected by our General Assembly and our legislators to make the determination as to what is the best sentence, not only for the crime that the person committed, but also the mitigation factors that the court must consider when you do an individualized sentencing. And that cannot be soft on crime.
I mean, I think I just have to say, we don't have to be tough guys about every single thing that comes across. It makes for really bad policy. Dr. Nellis already told us that in a lot of these cases, these sentences increase crime. So if you think being, tough on crime means doing something that eventually increases crime, okay. I think there are people who think this way. And I think the answer is if someone calls you and says, hey, everyone should always get the harshest punishment possible, or should automatically get a harsh punishment no matter what the situation is, you can try to educate that person. But ultimately, if a legislator is thinking that way, we need a new legislator.
Right.
Vernida, I wanted to give you one last chance. There was a question about implicit bias and the effect that can have on the system. And I think it's important to understand that a lot of times we're talking about people in a system who aren't trying to have, racially inequitable effects of their work. And, we've talked about when you put a system in place, when you design a system well enough that the people within it work without realizing that they're doing your bidding, right? And I feel like for 100 years, Virginia a lot of the criminal justice system has been designed to control Black people. And that was your beginning in the Civil War, before the Civil War on the plantations, and that a lot of that mentality in terms of how we design the system is still working. And then lots of people like us who don't think that they're doing something bad or don't think that they're creating racial inequities are still doing it anyway. So how does that work? Well, why is that still happening?
I mean, implicit bias, we talk about it a lot, but I mean, it really is the attitudes and stereotypes that affect your understanding and your actions and your decisions unconsciously. I mean, we definitely have some people that have biases and they are very explicit about it. They're on Front Street about it, right? But we have a lot of people who don't recognize their attitudes and stereotypes, and oftentimes that is at a detriment to Brown and Black people. As you had said, I mean, our country, we have a reckoning that's happening right now, but we go back to slavery. The Civil War was about state rights, and the state rights were about keeping slaves. We went through Reconstruction. We went through the Jim Crow era, segregation of schools, and the war on drugs, which undoubtedly affected Black and Brown people. And now we're dealing with a reckoning today with the Black Lives Matter movement and the fact that we want people to have humanity for Black lives and treat us like human beings and not like animals that should be killed in the street. And so when we talk about implicit bias, it's important. It is important. I mean, when you talk about criminal justice and crimes, it usually always starts with some type of law enforcement officer. In my case with the young lady that was charged with assault on a police officer, again, she was a minority. Would those law enforcement officers reacted in that type of way if she was a young white girl? We don't know, but I've been doing criminal law for a long time, and I don't have very many cases like that when it's a young white girl or a young white guy, okay? The officers, what is their background? What are their influences? What is the culture of the police department? What are their commanders telling them about who they should go after? All of us have watched this recent video of the Virginia State Trooper who essentially choked and harassed Derek Thompson when he was pulled over for an expired inspection sticker when he was going to work.
He did it with a gleam in his eye.
Absolutely. He actually looked in the camera and was basically saying, watch the show. Would that have happened to someone that wasn't a person of color? I mean, we don't know. But we do know that he pulled over a person of color for an expired inspection sticker and then had that type of reaction when he wanted to try to search the car for supposedly drugs that was not in the car. And so it's this type of stuff, the implicit bias, the legacy of slavery, the legacy of racial oppression against brown and Black people that we're still dealing with today. And until we can get some changes in people's hearts and in attitudes, this is what we really need to have happen, in addition to changes in laws to make sure that Black and brown people are better protected by not having mandatory minimums, getting rid of pretextual stops, offering more due process rights in the criminal justice system.
Vernida Chaney, Premal Dharia, Dr. Ashley Nellis, I want to thank you all for your time. I want to encourage our listeners, please, the special session starts in 13 days. There's going to be bills coming through that are going to address these issues and other issues of racial justice and criminal justice reform. Please pay close attention to them. When the bills come through, if you're interested and you want to know how you can help, get in touch with us at Justice Forward Virginia. Get in touch with your legislators. Let them know what you think of these issues, what you think of these bills. Your involvement is really paramount. And I want to thank everybody here today for their time. And I want to thank those who are still watching at the 70-minute mark. And I hope everybody has a great night and we all get fired up for the special session. Thank you all.
Absolutely. Thank you.
Good night, everybody.
Thank you.